Welcome to today's program titled Keeping It Markedly Real, Navigating Trademark Law in 2025. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to Ken Wilton. Ken, you may begin.
Thank you much, Sadie. Hello, everybody, and welcome. Good morning, good afternoon, no matter where you may be. By way of quick introduction, I'm here with my colleague, Lauren Leipold. We're both partners at Seyfarth. We're both specialized in trademarks and kind of spend most of our days talking about trademarks. And so we've got this nice little presentation for you. And with that quick introduction, I'll turn it over to Lauren.
Thanks, Ken. You can go to the next slide. So what's today going to be about? Well, going into 2025, obviously there is a new federal administration in place and a lot of moving pieces as a result. We're not here to answer any questions about specifically what that impact is, what sort of impact that will have, because we don't yet know, quite frankly. There are discussions about the effects on staffing at the USPTO and how that might affect review time for trademark applications. But again, all of that's up in the air. So what we do know is that the cases we're going to talk about today are still good law, going to continue to be good law, and will govern moving forward. So our goal here is to share with you, as just unapologetic trademark nerds, what we have learned over the past year. Ken and I have practiced together for over a decade now, and every year we like to go back through some of the major developments in this area of the law. And, a lot of the cases we've seen are maybe just reaffirming what we knew. What we've curated for you today are a few blockbuster cases from the Supreme Court, but also a lot of more minor decisions that may have been overlooked, but really taught us something here. And we think it's enhanced our trademark practice, will help give us an edge as we are litigating our cases or as we are prosecuting new trademark applications in 2025. So we wanted to share those insights with you. Today, we're going to start by talking about some First Amendment issues that the U.S. Supreme Court has dealt with and what the impacts of those will be. There have been a few federal circuit cases that have also been quite illuminating. And then we'll discuss some other federal circuit and trademark trial and appeal board cases that have really clarified some doctrines and come up with some interesting findings that we think will perhaps impact the way that we do practice in 2025. And then finally, we'll end on a few cases with some more practical takeaways, some lessons learned when we both in the litigation context and in the prosecution context. So let's go ahead and get started with our Supreme Court cases. And we'll start with the big blockbuster case from a couple of years ago, VIP Products versus Jack Daniel's Properties. So this decision came out from the Supreme Court in 2023. Most of you guys have probably read the case, have probably seen, these pictures of the bottles a time or two before, but just as a reminder for background. So this all started when VIP Products, which makes dog toys, filed a declaratory judgment action back in 2014 against Jack Daniel's to get the court to say, and this is in the District of Arizona, to get the court to say, we're not infringing Jack Daniel's trademark with this dog toy that we are producing, and we're not diluting Jack Daniel's trademarks either. The dog toy is pictured there on the right. It was designed specifically to mimic a Jack Daniel's bottle, the look and feel of the bottle. You can see the similar fonts on the label. Jack Daniel's is replaced with Bad Spaniels. Old number 7 becomes number 2 with that obvious reference to the dog feces. And so in that respect is supposed to be a parody, and that's what VIP was relying on and asserting, this is not a problem here. People clearly are not confused, and therefore there's really no association made among the public between these two products. So after bouncing back up and down through the appellate courts, it started in the trial court, which originally found for Jack Daniels, went up to the appellate court, back down, the Ninth Circuit. And then finally, when the case arrived in the Supreme Court, the issue was really, what test should be applied when we are looking at a trademark infringement case where there's a First Amendment right asserted. Now, here we're talking about a parody, right? So the dog toy is clearly supposed to be a parody of the original. That's supposed to be protected under the First Amendment. And in fact, the Lanham Act's dilution statute has a carve out for fair use for parody. And so this was what VIP was relying on. The reason that this was such a big deal was that there had been a circuit split that had developed, and some courts were treating the case slightly differently. But in general, the Second Circuit case Rogers v. Grimaldi from 1989 would generally get applied in lieu of the traditional likelihood of confusion factors when a defendant asserts a First Amendment defense. And that Rogers test is much more lenient than the 8-factor Sleekcraft test in the Ninth Circuit. So the Rogers test just has 2 prongs. It says, is there any artistic relevance involved here? And if so, is there anything explicitly misleading in the allegedly infringing product that would cause consumers to be confused regarding the source or the content of the material at issue? So this would basically allow a lot of defendants to come in and basically get out at the motion to dismiss stage, because they could just, raise their hand and say First Amendment, and a lot of courts would be hesitant to do anything about it. So this became a big issue, and which standard would apply was a big issue. So in 2023, the Supreme Court said, look, you can't apply that more lenient test when clearly, as here, the infringer is trying to use the mark in a way that is a commercialization, right? They're using the mark as a source identifier. They're wanting you to think of Jack Daniels to drive the sales of the Bad Spaniels dog toy. So after that, in 2023, we've seen some courts trying to apply this standard with mixed results. And we finally now, just mere days ago, finally, the District of Arizona quietly came out with the new opinion. And so we actually know how it came out. And so on remand, they looked and they applied those traditional likelihood of confusion factors in the motion to dismiss, motion for summary judgment context. There was no trial here. Next slide. So what were the other courts doing? We saw the Second Circuit and the Ninth Circuit most active in this area, although there were a couple of cases trickling in the Sixth Circuit and others. The 10th Circuit has cited Jack Daniels, but in general, they were pretty, holding the line. Look, if you are using a mark in a commercial manner, you can't just rely on the Rogers test. And we saw that in the Punch Bowl case in the Ninth Circuit, which ultimately, interestingly, once it sort of wound its way back down to the trial court, the defendant ended up getting off anyway, because in that case, despite the fact that there were First Amendment issues, the court found the marks are different enough and the services at issue are different enough that there's no likelihood of confusion. It doesn't really matter which test you apply. So we didn't really see a practical difference, despite this academic question of which standard to apply. The court just continued to apply the same standard just as recently as December 20th, and they said, we're not going to dismiss based on Rogers. That's not to say that the First Amendment won't come into play later, though. Next slide. So what's interesting is that the Jack Daniels court on remand took a very careful look. There's a very lengthy opinion on this, in which the court looked at the difference between the harms, the nature of the harms for trademark infringement versus dilution. So, infringement, you're talking about really consumer confusion. You have to have consumer confusion, and there has to be a resulting reputational harm. Dilution is a special statute. It's a little bit different. You have to show fame of a mark. in order to become eligible to really succeed on a dilution claim. And it protects the distinctiveness and selling power of the mark. So a tarnishment or blurring of a trademark are actionable, and it doesn't really matter if there's any actual confusion or if there's any damage whatsoever. You just have to show there's some likelihood that people would perhaps make a negative association with your mark, or it would lose its distinctiveness in some other way. So the court looked at this very closely and ultimately found that, look, this is a parody. And, because it's a parody, we're going to find that it's not infringing. There's no confusion here. At the same time, because there's no confusion because it is a successful parody and people can tell the difference. But because of that, there is that dilution. There's that association between the two products that is going to cause harm to Jack Daniel's mark. And so the trial court comes back around to its original decision back from close to 10 years ago, when it said, we're going to find in favor of Jack Daniel's, we're going to issue a permanent injunction against VIP because this just isn't right. And it's not on infringement grounds, it's on dilution grounds here. What's really super interesting about the way that the court treated this case is that it didn't completely jettison the whole First Amendment angle. It basically looked at a Fourth Circuit case, the Hot Diggity Dog case involving Louis Vuitton marks, and it said, look, because this is a parody, there's a threshold test. We need to look and first see, is it a parody? Is it a successful parody? And then launch into those sleek craft factors. So they looked at, is there, does it evoke the original work that it's supposed to be parodying? And does it create some sort of contrast through humor? So the court said, yeah, this is clearly a parody. And therefore that really colored the way that the court went through the sleek craft factors, despite the fact that Jack Daniel's was able to show a 29% consumer association through a survey between the two companies. When consumers were shown a picture of the dog toy, 29% of the people said this comes from Jack Daniel's. That's pretty powerful evidence on its face. We also had just the unapologetic, undisputed, intentional copying of the mark and the similarities of the mark. And those are often very important factors in a normal likelihood of confusion analysis. But the court said at the end of the day, none of that stuff matters. It's a parody. People can tell the difference. So it's a very interesting way to sort of split the baby. It still gives some sense of First Amendment protection here and fold that into the analysis despite not using Rogers. But then at the end of the day, still sided with the Supreme Court. You cannot commercialize and make money off of something that's clearly designed to free ride off of another party's goodwill. And so that's why I say here, the takeaway is, there's less opportunity perhaps to succeed at the motion to dismiss stage after we've seen this play out. But it's still worth making those First Amendment arguments because courts still seem to care about them and still seem to figure out a way to come to the resolution that they want to come to, and sort of balance those public interests in that respect. We can go on to the next slide. So the next really blockbuster case here is Vidal v. Elster. This was a decision that came out in 2024 related to the applicant's attempt to register the mark Trump too small. You guys may remember that Marco Rubio made some derogatory comments during the 2016, it was before a debate in the 2016 election. And basically Elster latched onto that and said, well, I want to make this be commentary about Trump, him, his policies, etc. And so he filed for a trademark registration at the federal level for Trump too small for clothing. He got rejected. There are two bases in Section 2A of the Lanham Act that would potentially prevent registration of this type of a mark. The first is Section 2A, which bars registration of a mark that may falsely suggest a connection with persons living or dead. The court hasn't really addressed that piece. Interestingly, that is the provision that was partially struck down in one of the prior cases, which we'll talk about in a minute. This case focuses more on Section 2C, which bars registration of a mark that consists of or comprises of a name, portrait, or signature identifying a particular living individual, unless you have their written consent. Next slide. So I wanted to make sure to mention, for those of you who aren't familiar, the backdrop against which this was litigated. There was a trend over the past few years. The Supreme Court has decided to address First Amendment versus Lanham Act issues before and has addressed this clash, and in both prior cases, struck down portions of the Lanham Act that it found unconstitutional. You might remember that in Mattal v. Tam, Simon Tam and his rock band, The Slants, were seeking a registration. It was denied because the prevailing thought was by the Trademark Office, well, slants is a derogatory term for Asians. Tam said, look, I'm Asian. I'm trying to reclaim that, what you might think of as a slur. I should be allowed to register this. The Supreme Court ultimately sided with him, finding that it was viewpoint discrimination and struck down that portion of 2A. 2 years later, we saw Iancu versus Brunetti, and that was the situation where a guy was trying to register FUCT for use on t-shirts. This same thing happened there. The court looked at it and said, immoral or scandalous necessarily implies that you are putting a value system, overlaying that on your examination of the trademark application with whatever might be, societal norms at the time. And that's essentially viewpoint discrimination. So they struck down that portion of the statute as well. So many people thought going into the oral argument in this case, Vidal v. Elster, that perhaps the court would sort of complete the trilogy and would strike down this provision as well. Next slide. They didn't. Now, interestingly, all of the justices agreed that the name provision is not unconstitutional. They were careful to distinguish both of the prior cases, and they said, look, those cases were clearly discriminatory as to viewpoint. Here, we're not talking about that. We're talking about, it's definitely a content-focused statute, and in that respect, a lot of times that would be, per se unconstitutional. But here, we're going to take a closer look and see, is it actually viewpoint discriminatory? And the majority, which was authored by Justice Thomas, focused all on history and tradition, and looked back at like English common law from, forever ago and said, look, people have always had ownership of their own names. The Lanham Act has coincided with the names clause for eons, and there hasn't been an issue. And that's despite the fact that the Lanham Act itself is necessarily going to be, related to content because it expressly prohibits registration of marks that are confusingly similar. So that requires an examination of the content of the specific mark at issue. Yet, the public interest has allowed both this statute and the First Amendment to coexist. There's not been an issue, and there shouldn't be an issue here. Now, Elster tried to argue, well, look, wouldn't it be so much easier to actually get a registration if I were saying something nice about Trump? I mean, isn't this actually viewpoint discriminatory? And the court basically shot that down. They said, look, the Trademark Office has refused registration of welcome President Biden, I stump for Trump, Obama pajamas. These are not negative messages, but they are using someone's name without permission, and it's just not fair. And it also might create confusion about source of the products, which is the entire point of the Lanham Act, is to avoid creating that type of confusion. So here they said, unlike in Tam or Brunetti, we don't have to apply strict scrutiny. This is totally kosher. Now, they did make it very clear at the end of the decision. They said, look, this is supposed to be interpreted narrowly. We're not trying to establish some sort of comprehensive framework that says anytime you have a content-based but viewpoint-neutral restriction in the Lanham Act, that this will be the outcome. This is specific to this clause of the Lanham Act. So quite interesting here, but nonetheless didn't stop Elster from going ahead and continuing to use the mark. The registration prohibition clearly doesn't prohibit him from continuing to use the mark, and in fact, that's perhaps the way that courts have balanced those public interests. You see this shirt right here, Trump Too Small. I found that on trumptoosmall.com yesterday. These shirts are still being sold, and I think while there may be, again, this sort of academic exercise in terms of what standard to apply, in the real world, I don't know that it will impact necessarily what people are doing and saying in the marketplace, other than, perhaps preventing, purely just federal registrations, which do have benefits, but again, don't prohibit use of the mark in commerce. I'm going to turn it over to Ken now to talk about some recent developments in the federal circuit.
Thank you, Lauren. And just as a caveat, we are not endorsing any specific product or viewpoint. So we're going to talk a little bit about certification marks, because that's what everybody talks about when you're a trademark nerd. We have this case out of the Federal Circuit, which arose from a dispute between the two French entities that control the certification of cognac in terms of its content, et cetera, against an entertainment company. So why don't we go to the next slide? And certification marks, we've seen them in a number of different places. You see them like UL, Underwriters Laboratory, will certify electronics, that they're safe. They're in a variety of different industries. In the wine and spirit industry, there are usually geographic indications. There are AOCs in Europe, or in France, AVAs in the United States, and they're certifying something about the product. In the case of cognac or tequila, it's what content, how it's grown, et cetera. The Lanham Act does allow for the registration of a certification mark, specifically under 1054. And interestingly, the folks who control cognac have not registered cognac as a certification mark. So they filed an opposition against the entertainment company, Cologne and Cognac Entertainment, and it was based on their common law use. At the board, the opposition was dismissed, which leads us to the Federal Circuit. Next slide, please. So the Federal Circuit took an interesting path, which if you are the owner of or represent the owner of a certification mark would be good news for you. Because the board, when it was looking at the fame of cognac, looked at it from whether it was known for the certification function as a certification mark, or whether cognac was known simply as a mark in connection with distilled spirits. And so what the board found is that it wasn't famous as a certification mark. What the Federal Circuit said is, wait a minute, you need to look at this a little bit differently. You need to look about whether it's a designator of a regional origin, whether people would recognize cognac as some sort of French liqueur. Then the board the Federal Circuit went further and found that the board had erred in looking at the evidence. And this is rather interesting because the applicant took the position that the mark cognac only appears on bottles with a house mark. So I hate to do this to you, Sadie. Can you go back 2 slides? So if you look at this, whenever you see cognac, you see it with Hennessy or Martell, Remy Martin, et cetera. It always appears with a house mark. So continue down a couple of slides. The Federal Circuit pointed out that that's the nature of a certification mark. The certification mark has to be used by third parties in connection with some other mark. So the fact that it can only be used on a third-party product or a third-party brand doesn't negate the fact that the mark itself could be well known. And so as a consequence, one needs to look at both, needs to separate out. The fame of the house mark is wonderful over here, but for purposes of this opposition board, you need to be looking at the fame of the cognac mark. Similarly, the board had rejected the evidence of the usual evidence of fame that we all see, sales, revenue, et cetera, saying that those were driven by the house marks and not by the cognac mark. And at the end of the day, what the Federal Circuit ended up saying is cognac is a very well-known spirit. There's evidence that it's popular within the hip hop industry, which is where the applicant resides, if you will. And so remanded it back down to look at this all again. Next slide. So the story there primarily is that you can enforce these certification marks and look at them a little bit differently than maybe we've been looking at them in the past. Next one's way more technical. This is a color mark, which are always fun after Qualitex. Now we all know that you can register color marks and how difficult it is to do that. But this one took a slightly different turn. Ceramtech and CoorsTech are competitors in the hip replacement product market. There aren't a whole lot of folks who do that. There are two of the competitors. And Ceramtech was able to obtain registrations for the color pink as used on the sort of the hip joint ball that sits within your hip. I'm not going to get into that. For one, I'm not a doctor, just a trademark lawyer. But they got these two registrations. Coors Tech didn't appreciate that, not only filed a petition to cancel. If we go to the next slide. They petitioned to cancel. They also filed a lawsuit, which incidentally was dismissed on personal jurisdiction grounds on appeal. So as a consequence, they filed this lawsuit. Petition to cancel was suspended, as that always happens when you have a pending federal court lawsuit. But when that lawsuit was eventually dismissed on appeal for lack of personal jurisdiction, it went back to the board. So the argument being made was that pink is functional in the context of these devices. And it's functional because chromium oxide turns the little ball joint pink just by the chemical reaction of it, but also is useful to make it hard, make it harder than other substances. So when you're registering a color mark, as we know from Qualitex, it has to be distinctive and not functional. So here, Coors Tech focused on the functional part, ignored the distinctiveness part, and said there are two types of functionality, one beyond the scope of what we're talking about, which is aesthetic functionality, but the other one is utilitarian functionality, which is whether the mark as described in whatever you're applying for is essential to use the article or essential for the purpose of the article. And there's this four-factor test coming from the predecessor to the Federal Circuit from 1982, which is set forth here. One of the factors is looking at utility patents that might be owned by the registrant or applicant. The applicant or registrant's advertising, whether they're touting the utilitarian advantage of whatever is being claimed as a trademark. And then there's alternative designs, and a lesser issue in this particular case, which is whether it relates to the expense of manufacture, et cetera. So next slide, please. So the parties stipulated that adding chromium oxide turned things pink. Simple. The next question became whether the chromium oxide was a useful part of the inventions that were disclosed in the utility patents owned by Ceramtech. And in determining that, the board made the comment that you don't just look at the claims of the patent, for those who play in the patent world, you look at the totality of the patent itself, specification, abstract, et cetera, as well as the prosecution history. Those patents disclosed that chromia made the substance harder. Next, the board looked at the advertising. And the advertising also, and technical papers submitted to various peer-reviewed publications, and said in those papers, the point was made that chromia was a useful thing to include in the hip ball joint, or the hip ball, because it made it harder. So at the end of the day, the board concluded that primarily because of the utility patent and the advertising, that pink was simply there because chromium oxide was there, and that served a function, utilitarian function for the product. Next slide, please. The Federal Circuit, in a moderately uninteresting opinion, honestly, just affirmed the finding of the board below, and it made an interesting comment about unclean hands. There was an unclean hands defense raised by Ceramtech as to Coors Tech's activities. And the board below said that even though equitable principles apply, if there's a public interest in canceling the registration, the board in its discretion can say, no, you cannot raise an equitable defense. And if you think about that from the perspective of maybe abandonment, that there's a public interest in removing dead wood from the registrar, then maybe it makes sense. The Federal Circuit said the board had gone a little bit too far in stating it's never available in a functionality dispute, but nonetheless affirmed, saying that the board had exercised its discretion to not consider it. And on a somewhat personal note, the opinion is very interesting. It was written by the late Jonathan Hudis. It is 75 pages long. and it shows how deep he got into this thing. There are chemical equations in it. There's all kinds of stuff. So that's just a note. If you want to go read an incredibly detailed opinion on functionality, I recommend reading it. Let's go to the next slide, please. Next slide. Let's move on. Let's see, go on to the next one, please. So I'm going to turn it back over to Lauren to talk about Blizzard video games.
Yes, I am happy to jump in on this one. So this is one of those cases where maybe you blink and you miss it. It's not a super long opinion, it's precedential, but unless you are maybe an avid reader of the TTAB blog like we are, you may not have noticed it come out, but it sort of has this bombshell holding, in my opinion, in that it redefines what constitutes a service under the Lanham Act for purposes of getting registration. So this case involved what initially was just a run-of-the-mill opposition, and the opposer, Blizzard Entertainment, opposed a registration or an application based on its prior registrations in International Class 35 for retail services for its Blizzard and Blizzard Entertainment marks. The ID read electronic commerce services, namely providing online retail store and mail order services, all featuring clothing, books, mouse pads, toys, games. So the applicant in this case said, well, wait a minute, I don't think you're actually using this mark for anything that would actually be recognized as a real service to support a registration. And so they countered with claims of the fact of no use in commerce. So this mark has never been used in commerce, which is grounds to cancel the registration. And also, I want to cancel based on abandonment, which after 3 years of non-use, there's a rebuttable presumption of abandonment, assuming you can show intent not to resume use. So this teed up the question of, okay, well, what's a service under the Lanham Act? So the Act defines service mark, but it doesn't separately define what a service is. It says that there's clearly a process for registering a service mark, but conventional wisdom over the years for anyone who's practiced in this area is basically your service to qualify as a real service has to be something that you're performing for someone else. So over the years, there have been basically 3 factors that have evolved through the case law at the TTAB. So they say, well, it's got to be a real activity that's actually being performed. And the second qualification is asked to be performed for the benefit of someone other than the applicant, as I mentioned. And then it's got to be something qualitatively different from anything done in connection with the sale of the applicant's goods or the performance of another service. So under this traditional wisdom, you really wouldn't be able to register retail services involving just sale of your own goods, because it would be just for your own benefit. You're not really doing anything for anyone else. So over the years, there has been case law that's developed, and they said, well, I guess it's okay if you benefit so long as really the primary beneficiary of the service is someone else. And then the question, of course, remains, okay, well, who primarily benefits? And Ken and I have litigated over this issue and against a bully, no less, which I'll talk about in a moment. And it's just really not clear where the line is drawn. So it's been interesting to get this guidance. Next slide. And the TTAB said, look, actually, yeah, you're right. At one time, we didn't recognize retail store activities as a separate service. So you could get a registration for whatever goods you were selling, but then not also couple that with a Class 35 registration for the related retail services. They said, well, actually, now that we're thinking about it, curating all this stuff, putting it together in a place, whether it's online or in a brick and mortar store, you're making it available for people. They can choose what they want of your curated selection. You're making it easy for them to purchase by creating, a payment platform, et cetera. And so that constitutes the payment of a service, and it primarily benefits them, even though technically, yeah, you're making money off of it too. And they said, well, the activity provides a central location to find, examine, and purchase various goods. That's the nature of the activity. And so therefore, it primarily benefits consumers. But as I mentioned, this is a super short opinion. It doesn't go into any detail in terms of, why it's considered primarily to benefit the consumers and where you draw that line. So we're still missing a lot of guidance in terms of the specifics. What is clear, though, is that it really paves the way to shore up a client's trademark registrations or your company's trademark registrations in the event you want to get, say, you sell clothes in class 25, and you also want to get that corresponding class 35 retail services. That is clearly available under the precedent set in this Blizzard case. I do want to mention, I focus a lot of my practice on enforcement, and I don't know from a practical perspective how much that actually matters. Because if you've got a registration for the underlying goods, there's, it's axiomatic that the services, the retail services are going to be related. And so you could probably use the registration for the goods to enforce against someone who's trying to do similar retail services. You probably wouldn't have a problem. That said, I suppose I could see a situation in which you're trying to perhaps keep the register clear, perhaps educate the trademark examiners about what the scope of your rights are, and perhaps make it easier to help flag for the examiner, we're already occupying class 35, and then hopefully block others from getting on the register with similar marks. So just something to consider in your registration strategy. I think it could go one way or the other depending on what your ultimate business goals are. I've also found that having a registration that's directly on point can be helpful when you're sending a demand letter to those, perhaps less sophisticated parties, mom and pop shops that don't really understand that if you don't have, they seem to think that there has to be an exact overlap between the mark and the goods and services in order to be actionable. And it's sometimes difficult to convey that there doesn't have to be that exact overlap in order to be actionable and constitute infringement. And so this perhaps is helpful in that respect. So I want to raise that with everyone so that you can sort of put that arrow in your quiver as you're considering your registration and enforcement strategy. Next slide.
Let's go back to this slide for a second. Previous slide. I've had an observation. I don't know if it's a question for you, Lauren, but would this holding apply to advertising services, which we see often that folks will try to register their mark for advertising services when they're simply advertising their own product. But looking at this analysis here, maybe even the process of advertising benefits consumers more than it benefits the person advertising. Not sure I'm looking for an answer to that, but
I think that's a great question. I think this definitely leaves room to make that argument. One interesting observation I guess I had in reading the case is sort of like, well, are they really just confronting the reality that a ton of people out there just already have these retail registrations for their own goods? I mean, I can think of many clients that just already own these, and they didn't have a problem. They sailed through the trademark office. And so maybe there is a shift towards realizing what's a little bit more practical, and maybe, you could at least make that argument. But I don't think I've seen a case yet that actually addresses that question. So it'll be interesting to see if that develops.
That'll come next year.
Good question.
Now we're going to turn to a case that actually involves a restaurant that is essentially a couple of miles that way, for those of you who live in Los Angeles. Dan Tana's restaurant was opened in 1964 by a former professional football player. It is still open. It is one of the mainstays, one of those old-time restaurants in Los Angeles. And this dispute involves it. And for those worried about copyright, that photograph was taken by one of our associates who, when he was looking at the case, decided to drive out and take a photo of it. That is the kind of initiative that we want around here. So Dan Tana has operated for years, and then a company called Great Concepts out of Georgia registered Dan Tana's for restaurant services. Slightly different spelling. Mr. Tana himself petitioned to cancel it in 2006 and filed a lawsuit in 2008. This is where the case gets interesting, or the ruling gets interesting. In 2010, while the petition was pending and while the case was pending, an combined 8 and 15 declaration was filed on behalf of Great Concepts by its outside counsel. Noted below, March 8 is when it was filed. July 15, the appeal was finalized, and December 14, the TTAB dismissed the cancellation. So the question was whether or not the claim under Section 15 of incontestability was fraudulent. Next slide, please. As we know, Section 8 requires a sworn declaration that the registrant is still using the mark in commerce in order to maintain the registration. Section 15, on the other hand, requires a declaration that it has been in use for the last 5 years and there are no pending proceedings involving the mark. The board found that because both the first petition to cancel and the appeal were pending, there was fraud and canceled the registration. And I have a cautionary note at the end of this, which we'll bring up. The next slide, please. So it goes up to the Federal Circuit, and the Federal Circuit decides to look at this case from a pure statutory construction point of view and says that the Section 14 only allows for cancellation for various different reasons, but it allows for cancellation at any time if the registration was, quote, obtained, close quote, fraudulently. And so the majority decision was because the Section 15 Declaration of Incontestability or obtaining incontestability status has nothing to do with maintaining or obtaining the registration. There was no fraud in the context of Section 14, subsection 3. So they parsed. Section 8, if you lie on that, there's actually case law that says if you commit fraud in your Section 8 declaration, you can lose your registration. But Section 15, because it doesn't relate to maintaining the registration, that fraud doesn't matter from a cancellation perspective. A couple of quick takeaways. One, the dissent notes that the PTO usually has discretion to control how people act in front of it, just as it does on the patent side, it does on the trademark side. Also made the observation that this is a combined declaration, so it has one signature for two different statements, and if a portion of it is fraudulent, shouldn't the whole thing be fraudulent? The last point to be made is one that I know has come up over the years, is it was signed by outside counsel. And the consequence of that in this case was kind of interesting because outside counsel was also counsel on the petition to cancel and also counsel on the lawsuit. So from the board's perspective, that individual had knowledge that should have stopped them from signing the Section 15 declaration. I personally try not to sign anything on behalf of my clients, but this is one instance where it created a different problem, which is that the knowledge that would be the premise for the fraud was actually had by the individual signatory. It may not have been had by somebody at Great Concepts. Something to think about. Let's go to the next case, please. Moving over to trademark bullying, which Lauren alluded to. What did DoorDash say?
We all hate those trademark bullies, don't we? These last couple of cases we want to end on with, they're just sort of, they're kind of smaller, more practical takeaways to think about. So when you're out there, responding to a notice of opposition or filing a trademark opposition, you seem like you know what you're talking about here. So this trademark bully decision is really interesting. The DoorDash case, because I think we probably all, or most of us here, have litigated against a trademark bully before, those types that file oppositions against what seems like anything, including stuff that just doesn't seem like it's anywhere close to their marks, and then just continues to, pound you in litigation to the extent you can at the TTAB. And it can be really frustrating, right? Because you have to respond to it on behalf of your company or your client. And the TTAB isn't empowered to issue monetary sanctions, so you can't get fees for having to litigate over all of these minute issues and deal with it. So it's become sort of a term in common parlance among trademark practitioners. And McCarthy, who is sort of his treatise is sort of the Bible for us trademark lawyers, has called the trademark bully a party that asserts an unreasonably inflated view of the exclusive scope of its mark, as I alluded to before, is overly aggressive in its demands, feels like they're not proportional to what's really going on, and there's probably not going to be any actual confusion or likelihood of confusion in any practical respect. And it's usually a bigger company with a lot of, maybe even close to unlimited assets to really just grind you into oblivion with, a million and one discovery requests, et cetera. And then, the one being accused of infringing is usually this smaller business owner just trying to protect their rights. A lot of times they don't necessarily know that they've done anything wrong, don't think that they've done anything wrong. Maybe they haven't. So there's just this kind of general concept floating around, and people have, with varying success, tried to assert that in a TTAB proceeding and say, well, that should count for something. And so what this case counsels against is actually going ahead and doing that and asserting it as an affirmative defense. Next slide. So this, as I mentioned, has been an affirmative defense raised with varying success. Basically, parties will generally plead it as a species of unclean hands. That's a defense that's going to require some sort of bad faith on the part of the other party. Importantly, it's not just bad faith in general. It has to be bad faith as related to the specific claim at issue, and that's what gets a lot of parties with this unclean hands defense. But it is in the roster of those defenses that equitable defenses, people will often raise when they're responding to a notice of opposition. And so the applicant in this case thought, well, let me raise this here. It seems like DoorDash has filed all kinds of things. It just feels like they're going overboard here. So looking at the landscape of the case law and deciding how they would plead this, it's been a mixed bag. You tend to have more success with this type of defense in a court, which will look, at a lot more, take a more expansive view at the issues, and we'll look at the overall landscape. We'll look at the behavior of both parties in the marketplace, as opposed to the TTAB, which really is sort of laser focused on what is within the four corners of the registrations asserted and the application that's been posed. So courts will sometimes see trademark misuse and they'll accept it as a defense, and they'll say, well, this is sort of kind of a form of anti-competitive behavior. It might be an antitrust sort of flavor to it. And so some courts will say, well, they've proved enough evidence, or at least provided evidence in the record to support their allegations that, these marks were specifically being used for the anti-competitive purposes. And they'll look at, if there's the tie between the claims at issue and the trademark, or whether it's just, bad faith in general. And they're not going to entertain bad faith in general, typically. The board, on the other hand, basically always has rejected this approach. And, dating back to 2002 and even earlier, the cases cited in this opinion I reference here, the board says, look, we don't have jurisdiction over federal antitrust issues. Like, that's a totally separate statute. We are empowered to act under the Lanham Act related to confusing similarity of marks. And when a party is asserting a claim that is just exercising their express rights under Lanham Act to prevent registration of a confusingly similar mark, or what they believe in good faith is a confusingly similar mark, that's totally fine, totally kosher. That's exactly the point of the Lanham Act. And again, you have this more myopic view at the board where we're not talking about this series of historical events. We're talking about what's going on here and now with this registration and this opposition. So quite an interesting take on it, and yet not that surprising when you kind of think in the larger perspective as to how the board will generally approach these issues. Next slide. So the DoorDash decision kind of put a nail in the coffin in terms of any attempt to try to plead this sort of thing in the future. I will say I myself typically take the stance of I'm kind of anti moving to strike affirmative defenses. I usually think it's kind of pointless because, the party might not be able to prove it anyway. And even if the board might grant your motion to strike, they're probably just going to let the party replead. And typically speaking, they might strike a defense because it isn't pleaded with enough specific facts to support it. And then, the party can just go in and add those facts and their allegations. They're sufficient to stand at least, at the initial stages of the litigation at the board. So typically I find it's a waste of time and resources to do that. But in this case, it wasn't. And the motion to strike that DoorDash made was successful. So it's interesting to take a look at specifically what the applicant pled, because I know I've seen a million answers where someone just literally lists unclean hands or trademark bullying or whatever and doesn't provide any factual basis for it. Here, the applicant tried to do that and said, this opposer has engaged in trademark bullying. They're among the top filers of TTAB proceedings. They didn't provide any specific numbers in the pleading, but alleged that. They allege that, they've previously opposed all of these other applications on dubious grounds. We're just a small, poor little business. We can't, afford to defend ourselves against these bullies. It's just really not fair. And they cited to some other cases where an unclean hands defense for trademark bullying was entertained, at least at the initial stages. And the board said, well, those are all different. Those were related to kind of like antitrust in the court context. And here we're really just talking about them trying to enforce their rights as to these specific registrations and this specific application. And that's all that issue. And that's all that's at issue. And they're definitely allowed to do that. So, they said, look, like the Trademark Act doesn't talk about bullying. There's no prohibition on bullying, whereas there's express provisions prohibiting registration for various reasons, like we talked about at the beginning of this conversation, using someone's name, etc. This is not one of those exceptions. And so you can't just say this guy is being a bully and whine about it. That's just not gonna be enough. And I have not seen a case since this that really has had any success in making any sort of a more clear claim as to bullying. So it's a little bit disappointing in that if you've been on the receiving end of a trademark bully, you want to be able, you want that to matter. I have seen some situations where the board has expressed displeasure, sort of intimated it in the language of their final opinion, but never again come out and said anything. So we're still sort of defenseless at the board in terms of trademark bullying. So keep that in mind when you're pleading, and keep it also in your back pocket if someone tries to assert that defense against you moving forward. Next slide.
Before we go to locus link, one observation on a comment you made, Lauren, about motions to strike, and I agree with you that they're usually not worth the effort. One approach that sometimes works is if you have a response that has maybe a slew of unsupported affirmative defenses, is to ask the interlocutory attorney to participate in the discovery conference. Because usually in that process, there is a review of the pleadings, and I have found instances where in that review, the interlocutory will strongly suggest that certain affirmative defenses should be taken out of the answer. So it's one approach to avoid motion practice, which really doesn't really have much utility, but this is one way of maybe approaching that problem. Last case
I definitely second, oh, sorry, go ahead.
Go ahead, no.
I was just gonna say quickly, I definitely second the recommendation in certain situations to involve the interlocutory. They can be helpful in conveying a message in a way that, you as the advocate for the other side is unable to do.
That imprimatur of authority is a good thing sometimes.
Yeah.
Very quickly, I'm going to talk about this case, in re locus link, only because it's the first appeal of expungement decisions to the board. And for those who recall, the TMA introduced 2 new proceedings for addressing marks that were registered for goods on which the mark was never used or hadn't been used in quite some time. You have expungement proceedings where it's never been used on certain of the identified goods or services. There's a time period in which to file for that. Or a reexamination where the mark wasn't used on the date that the applicant claims it was being used. And those also have the time period. interesting observation. Last year, we gave some statistics in terms of the status of expungement and reexamination proceedings. This year alone, they doubled, which I found intriguing because it's been around for a couple of years now, and I'll have the stats show up in a page or two, but they're now being used more and more and more. So quickly on Locust Link, next page. Locust Link focused on the identification of goods in 2 registrations for Smart Lock. And if you look at this, this is something I know we've all seen before. We have some phrase followed by namely, followed by another phrase. And for those who are in tune with this, you'll realize right away the phrase evaporative air coolers does not describe products that appear in the specimen below. So go to the next page, please. Nope, one back. So the focus in the expungement proceeding was on the word namely. Namely, in the context of an ID, it clarifies the wording that precedes it with something more specific. So quite simply, what follows namely has to be a subset of what precedes namely. The problem that Locust Link faced is that, as described in the ID, evaporative air coolers was not a subset of components for such systems. As a consequence, because the mark wasn't used on an evaporative air cooler, it was the board found that it had never been used before. Or actually, the PTO found that the mark was not used on the goods identified in the application or the registration, and as a consequence, both registrations of Smart Lock were canceled. So riffing back to Lauren's comment about use and registration, companies still using the mark, which they have every right to do. Just the registrations were canceled because of that wording. So the takeaway is the wording of the ID matters. Care should be taken when deciding how it should be structured and what words are said. And obviously, what we all want to do is we want to make sure that everything that is identified is something that is being used, especially in a use-based application. So next slide, real quickly, the numbers. Once again, the director of the office is using reexamination a lot. We have 5,000 that have been filed by the director. And that is really it. Since we're running out of time, there was one question, but before we go there, maybe we let's put the CLE slide up. To get your CLE credit, scan the QR code, and there's a number that you'll see. It says attendance verification code. Please put that in there. And there was a question I wanted to, it was related to the Vidal versus Elster.
For those who maybe are having issues with the QR code, let's just make sure. The verification code is SS0014.
Great. And I believe there's a link in your registration confirmation that can get you where the QR code would get you. So, query for Lauren. In the Elster case, if Elster had used Mary Trump's hand and got Mary Trump's permission, may she rest in peace, Mary Trump's permission to use her hand and her name, would it be in the same position? Would the case have ever made it up to the Supreme Court?
I don't think so. I think permission changes the game. And I think that's kind of the easy answer. Now, interestingly, you might be invoking perhaps name, image, likeness issues. You'd have to make sure that you iron that out with Mary Trump. But assuming you got permission in all respects for how you wanted to use the mark, I mean, tell me if you disagree, but I don't see any issue with that. I think that it would have turned out differently than Elster.
I think you may be correct. I wonder if the board or someone would look at the underlying purpose of it at that point. Because what if you found somebody living in Nevada named, Seymour Trump, and you used that person's permission? Just to,
which I guess theoretically you could, because in the context of applications for cannabis and things that aren't legal yet on the federal level, the board will go and do its own research and will say, you said that this was for t-shirts, but it's actually to promote your cannabis business. So it could be that they'll do, although I suspect that we're about to find out perhaps there will be some staffing strains to come full circle on the USPTO, and they may not have the time to invest in that.
Very true. So thank you, everybody. We really appreciate you all attending today. If you have any further questions, feel free to write to either or both of us. And you get the last word, Lauren.
Thanks for attending. Our contact information is here. If you have any follow-up questions, we'd be happy to answer them for you. Thanks for coming.